removal of the children from one country to another, and often from one legal system into another legal system, therefore that the approach of nationalism, patriotism, or other suspicion of foreignness is not an appropriate approach. The approach should be a strong approach, with very few exceptions that are contemplated, of applying the convention and leaving it to the country of ordinary residence to determine whether the children should be allowed to reside somewhere else or whether the children should stay in the place of residence. So that's basically what I came to say, and everything is said brilliantly in my article, and I'm very glad Justice Forrest has made his decision and that it was upheld by the High Court to give at least one of the 6 cases a case affirming the operation of the convention, and now we will have the interesting bit, Q&A. You can express your point of view. You may not agree with me about this. You may think, well, if a child is abducted, there must have been some purpose in it. Or if a child is abducted and the case comes before a court and there are exceptions, then the court just has to go through the process of hearing the exceptions. That a court is not on automatic pilot, and the regulations don't contemplate automatic pilot. A court is a court of law and justice, and therefore a court cannot but be concerned about the legal and justice issues that are raised in these cases. A court is required to determine whether or not the child and the parents had ordinary residence in the place from which the children were abducted. That's a factual and a legal question, and therefore it has to be seriously decided. It can't just be assumed. And similarly, if there are risks to the children, those are very serious matters affecting children. They have to be considered and determined. And if that takes time and slows down the process, and sometimes leads to a frustration of the overall great scheme of the international law, never forget that behind every case and every individual dispute are human beings, and decide those cases fairly and justly in accordance with law. How do you reconcile that obligation with the overall scheme, which, if countries don't conform to the scheme, will bring down the whole pack of cards? That's the question that was concerning me and concerning Justice Nye. And so that is the issue which presents a sort of paradigm case of the operation of an international principle. Was I being too absolutist? Was I a person who was hard of heart and giving no thought or insufficient thought to the dear little children who should be thought of here? Was that because I had no dear little children of my own, that I was purely lost up there in the clouds and concerned only with the theory of international law? Or was I being faithful as a lawyer to the principle of reciprocity and mutuality, without which the scheme will not operate? Okay? So that's the question. Any observations? First of all, a big round of applause to the speaker for don't get carried away. Yes.
I'm very interested in the effectiveness of things like this Convention on Child Abduction, and I wonder whether these cases highlight the fact that if individual states are just going to superimpose their own view on how these particular issues should be determined, like, is there any chance of things like this convention ever really being an effective international law, if you assume international law should encompass the world?
the authorities in The Hague and the special commissions that monitor the convention and the operation take out statistics. And the first observation I'd make on your question is, it wasn't really a case of the state. It was a case of courts, independent courts, making their decisions. In fact, after the first case, which I think was De L, where a question of whether the children had expressed a desire to stay in the place of abduction, whether they objected, there was a feeling by the state, that is to say the Attorney General's Department, that the majority in that case had misconstrued what they were intending to say in the regulation, child abduction regulations that gave effect to the Child Abduction Convention, and therefore they proposed to the government of the day, and the government proposed to Parliament, an amendment of the regulations that made it absolutely clear that objection was not to be construed as simply saying, well, look, I'd prefer to stay with mummy here, but was to be a mature expression of a strong wish not to be sent away. And so, in effect, by amending the regulations and by incorporating that clarification, the state was, first of all, subscribing to the view I had taken about the meaning of objection, and secondly, giving effect as best it could by the addition of words to what it also saw as the obligation of Australia under the Convention. So I don't think it's fair to blame the state, though of course judges can sometimes share the attitudes of the state. If I can say so, white Anglo-Saxon countries are a bit inclined to think that they're very superior and therefore that to indulge either expressly or perhaps subconsciously in a feeling, well, you can't expect those other people with their peculiar legal systems to be able to do it as well as we would do it. There's a lot of patriotic writing on this subject in the decisions in the United States of America. Although in Australia we don't quite get the same patriotic rhetoric, a question arises as to whether these subconscious feelings of, well, we've got it before us, and there's an exception, and there's a child involved, and therefore we'll make our own decision on that. Yes?
With that sense of patriotism or nationalism or sort of legal cultural superiority, does that sort of manifest itself more strongly in this area than perhaps other legal areas, legal disputes that have an international dimension?
Absolutely, and in fact the attitude of Justice Scalia in the Supreme Court of the United States is so hostile to any consideration whatsoever of the opinions of the international community or of foreign states, that he is extremely rude, some might say even, with respect to his honour, aggressive and angry whenever his colleagues make reference to any international principle. Now, back in the 1990s, a number of the justices of the Supreme Court of the United States began doing what I was doing in Australia and referring to international principles or the decisions of foreign courts, where there was an analogous problem coming up in their final national court. And so angry and hostile did Justice Scalia's criticisms of his colleagues become that I noted a sudden drop away of any references of this kind I mean, if you're going to be lambasted by a colleague, why would you bother? I mean, the path of safety and low emotion may be by just not going there. And basically that is what happened in constitutional jurisprudence in the United States of America. I think it arose in a case called Atkins against Virginia, which was a case concerning whether the United States constitutional provision forbidding cruel and unusual punishment would be enlivened in a case where a child under the age of maturity was sentenced to death. That was a question arose. And the majority of the Supreme Court of the United States said, well, look overseas, and in the whole world there are only X countries, I think it was 5. They were China, Iran, and other countries that are not normally taken as good analogies to the law. Therefore, if you're thinking of what cruel and unusual punishment means today, it's appropriate to look at that fact. Well, that turned Justice Scalia ballistic to think, first of all, that you were looking at